Hello, I'm Anavultus, and this is my dear co-host.
Hello, hello, hello. I'm Wyatt Berckenhoff, or the Breakdown with Berckenhoff, or the Breakdown with WB, and I'm happy to join you to this morning as well.
Yep, and together we are getting the answers. And today's question, I suppose, for which we are getting answers, is the question of trial by jury in the United States and things related to that. Perhaps even some recent events relating to juries, and we'll take a look at that and we'll see what we think about it, what's written in the law about it. Although in the US, each state has its own laws, so obviously not everything is going to be the same everywhere. But I think it is nevertheless something that, at least constitutionally, there is an idea that we can look into. So, um, do you have anything to say before we start?
Uh, to throw one kind of general thing out there, like I don't think every American views the jury in a similar way, and I think it also kind of influences who ends up being on the jury a little bit, and I think we're probably going to get into that. But kind of what I mean by that is I don't think a lot of people really want to be on the jury so much. And that's good and bad when it comes to who actually ends up there, such as jury duty. You hear a lot of people who, when they get the call and potentially be chosen to be on a jury, they're not exactly too thrilled to have gotten that message.
Yeah, I know a guy who recently got called to be in jury duty, and he decided that he would ask for it to be postponed, and we'll see what happens there. But uh, yeah, a lot of people, for them, jury duty is something that might disrupt their routine. It might disrupt plans that they have for a particular time because it requires a commitment in time. And of course, people are usually paid a bit, although it is an inconvenience for a lot of people. But anyway, I'd like to look into what exactly is meant by a jury, as is written in the law. Now, to talk about juries in a general sense, a jury is when a group of people are called together to make a decision on a particular case. So there's two kinds of juries primarily. There's the grand jury and the petite jury. The grand jury is a larger jury of usually 16 to 23 people who decide whether a case may be prosecuted if there's a probable cause in the case. So they look at a case before even a trial occurs formally, and they ask whether there should be a trial on that in a criminal case. So, what the US Constitution says about this, let me just pull that up here. So, what
Yeah,
the,
so we were. No, go on.
yeah, so let me just make sure I've got the right thing selected. There you go. So, what the US Constitution says here in regards to that is in the Fifth Amendment to the US Constitution, and it goes as follows: no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. You were going to say something?
Yes, just before you read into that, one thing that I think some people believe with the grand jury, and you can definitely let me know if I'm wrong about this opinion, and I think is why some people don't necessarily understand it is so recently when you hear about grand juries, whatever comes out from it, you don't necessarily know all the details of what exactly happened. In other words, they tend to be more in like mystery of their decision than a regular, say, normal trial, just to use basic words.
According to the regulations that exist, grand juries are supposed to be secret and confidential, and the exact things that a grand jury looks at are not known unless they are also being used as evidence in the trial. So, if, for example, the defendant says something to the grand jury and that influences their decision to put the matter to trial, then as part of it. So, in that sense, that's one of the ways in which the grand jury works. And I think in Supreme Court decisions, the confidentiality of the grand jury is strongly maintained, and the defendant himself is very frequently not even confronted by the grand jury, uh, because what the grand jury is looking at is not to actually try the defendant for his guilt. They're simply looking for a probable cause that the defendant may have committed a crime, and that therefore the district attorney or whoever is prosecuting has something to actually go on as a case, and that therefore a trial would be necessary. Now, in the case that, for example, a plea bargain occurs before the grand jury proceeds, then obviously there's not even going to be a trial, and the grand jury becomes unnecessary because a plea bargain has already been reached. And that does happen on occasion. But generally speaking, the grand jury operates in total secrecy, and the defendant does not have a right to be confronted by the grand jury, although the grand jury may contact the defendant and look at a statement the defendant makes. It all depends on what they are being directed to look at as a possible probable cause. And of course, the exact nature of this depends on each jurisdiction that has regulations on these proceedings. But
Because as you mentioned before, they it depends a lot on which county really you're in, even more than just what particular state. Because even some counties have their own particular rules. But really, it's just a state level. But Texas is going to be much different than California when it comes to how grand juries work, and Florida is going to be much different than any other state on how that works. So,
yeah.
but
And once again, I want to emphasize that the grand jury are only looking at whether a trial should proceed. They're not looking at whether the person is guilty or not. So if people fear that the secrecy of a grand jury is a threat to their liberty, they have to understand that in the actual trial, there is still a presumption of innocence regardless of what the grand jury finds. Now, of course, how the presumption of innocence is maintained is up to the petite jury, or the jury that's actually on trial there. But as far as I understand, most grand juries are composed through jury duty of various members of a community, in a similar way to the other more famous juries that people see in actual trials. And when I say that the grand jury operates in secrecy, that does not mean that they operate unsupervised, because the exact proceedings are recorded, although they are sealed, legally speaking. So they're not accessible to everyone.
Right, right. And it is a good distinction to make as well, because I think that people over a lot of times overthink the secrecy behind a grand jury just because people want to, know all the details. And I don't think that that's necessarily a bad motivation to know all the details. But that's not exactly how the system works. And like you said many times now, they're not saying that the person is guilty or not guilty or innocent. So it's not like their ruling has a finality to it unless they say that it doesn't have to go to trial or whatnot.
Yeah, all they're doing is looking at it and asking the question: is there, is it probable that a crime occurred here and that the defendant could be someone that committed a crime? So they're not looking at finding solidly whether something happened or not. They're looking at hypotheticals, in many cases, and if it is too shallow, if they don't think that it is likely that a crime occurred, or that it is, or that a reasonable argument could be made that the prospective defendant could have committed a crime, then they're simply not going to put that on trial, and the defendant may not enter into court at all. Of course, it depends exactly on how the legal proceedings go. But to round out what exactly the Constitution says in regards to a grand jury, I'd like to read here. So, what a grand jury is, provides a presentment or indictment for, is capital or otherwise infamous crimes. So a capital offense would be something for which you could receive the death penalty. An otherwise infamous crime could be a, a variety of other things, such as felonies and various things. So this does not really apply to a civil case where one private citizen is suing another private citizen over some injury or damages, but primarily refers to cases where you might have a district attorney or someone else prosecuting someone for a violation of the law in the strict sense, in a criminal case, that is. And the exception being that land or naval forces or the militia, when in active service in times of war or public danger, which means that if you're in the military or armed forces in some capacity and you're in active duty, in a time of war or public danger, that the grand jury does not apply to you. And it makes sense in that context that it wouldn't apply to that person, because you wouldn't really have time to gather a grand jury, and under an emergency situation, it wouldn't be easy to deal with that, especially if there could be military intelligence compromised through that process. So, in that sense, it makes sense to separate that from the military. But it is also important to note that no person, with the otherwise exceptions, otherwise mentioned exceptions, shall be held to answer. That is to say, that you can't put any person on trial for a capital or infamous crime without there having been a grand jury first.
For sure. And with military, they have their own sort of system as well for criminal charges, at least. and probably civil as well. But I know for sure with criminal that they have their own sort of investigation system themselves. Uh, uh, but that being said, I have heard of military officials being grand juried before, but it probably wasn't in a time of war or anything like you mentioned as well. So
Yeah, in the military, the trial goes somewhat differently, although there are still similarities and rules are maintained. It's just different, and I think it's different because it needs to be different due to the nature of military service.
right.
Okay, so but that's the grand jury. Do you have anything other that you'd like to say about the grand jury?
Just one other thing that came to mind that I've heard a lot from media recently about grand juries is the factor that I think people perceive the grand jury to almost be like a special privilege that, say, like businesses or rich people get to have. Like, in other words, Donald Trump right now is getting investigated for his business stuff and potential business financial fraud, and most likely, if they decide to charge him, he's probably going to get a grand jury first. So it's people like him who are able to get grand juries, but not, John Smith down the street. Is that a true claim? Because I
Um,
don't think that it's entirely true,
I
but
haven't heard it. If the nature of a crime is an infamous crime or a capital offense of some sort, then the Constitution would require that there be a grand jury before a trial proceeds. And I think in many cases there are grand juries. It's just because it's a relatively secretive process, it's very confidential that many people don't realize that there had been a grand jury. And in a high profile case, such as Donald Trump, to gather an impartial grand jury would be an undertaking in a similar way that other publicized cases require a more extensive and complex way to gather a jury, in essence.
right, for sure. The more popular you are, the more people are going to be paying attention. So,
Because if you gather a grand jury of filled with people that absolutely hate Trump, they obviously are going to say that he should stand trial, even if, hypothetically speaking, I'm not speaking for any jury, but hypothetically speaking, that there were no probable cause. Or if you get people that are hardcore Trump loyalists, they might say that he should not stand trial, even if under other reasonings there would be probable cause. So it's important to balance a grand jury in a highly publicized case just as much as it is important to balance a petite jury.
yes, a balanced jury is a huge, huge topic. And I think we're going to be getting into that later on this episode. But that's extremely important when it comes to both sets of jury for sure.
Indeed. So in that case, I think we can proceed to Amendment number 6 in the U.S. Constitution, which also mentions the jury. So to be exact, Amendments 5, 6, and 7 mention trial by jury in different ways. Now, number 5 dealt with the necessity of a grand jury in particular cases. And number six and 7 will deal more with the petite jury, as it is referred to. Although the Constitution doesn't refer to it as in that way, it's understood as being distinct from a grand jury, legally speaking. And the reason why it's called a grand jury and a petite jury is because a grand jury has more members than a petite jury, where a grand jury might have 16 to 23 members, with a 12-member majority being required in order to put a case to trial. A petite jury has 6 to 12 members, And I believe that though historically standards may have been different, nowadays there is an increasing need for unanimity in decisions. So let me get into that now. So the Sixth Amendment of the U.S. Constitution reads, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." So this, of course, the part of Amendment 6 specifically relating to the trial by jury is that it is a public trial. And of course, in all criminal prosecutions, so in any criminal case, the trial must be public, and they must have an impartial jury of the state and district, and that this district from which the jurors come from should be the same district as the defendant, and the districts can't be redistricted to the districts have to be established before the trial, and if, hypothetically speaking, the districts were to change during the trial through some legal process, I would imagine that this would require them to use the old districts, at least for any trial that has been established or put in the docket beforehand, any trial in which an indictment had been made beforehand.
Mm-hmm. For sure, yep. A jury being in its own district is also a very important concept, because you get to the whole idea of it needs to be a jury of your peers. And district by district sometimes is very different from each other, especially when you start talking about more, say, like rural areas, where you could have a little bit of a bigger city next to a town that isn't that big at all. And the people have very different living conditions and maybe even different morals or different dots, really, from even from district to district. So the idea of being inside the same district is a very important concept that makes high profile cases a little bit more complex.
Indeed. And of course, a big problem here is the question of the impartiality of a jury, uh, because though this jury operates openly because it's a public trial, they are also supposed to be impartial. So that means that in a high profile case, there's always a risk of jury contamination, which would mean that the jury in the trial would have their authority undermined, and therefore it could lead to a form of mistrial if the jury were to become impartial either before or during the trial. Sorry, partial before or during the trial, because they are supposed to remain impartial and only influenced by the events of the trial themselves, rather than by the surrounding media, preconceived notions, or other things. Now, of course, the exact way in which someone is supposed to be impartial is a bit difficult to define, because people will have opinions about various issues already before even having heard who's totally impartial on every issue. Is finding a balance between people of potentially different biases that together form a more impartial whole rather than individually being perfectly impartial.
Right, that was very well said, because when you think about trying to form a jury, and this was a high school project, it was a little bit silly, but I still think it showed kind of the difficulty of picking a jury. Basically, they had you like list all your friends and family, and say who you thought would be able to be on the jury who was impartial. And really, all of the people there could only put like two names down for everybody that they knew who they thought could fit that model of being, perfectly in the center, who doesn't have a thought, either way. And I just thought that that was kind of a very important thing, because the idea of finding 12 people that fit that, or in some cases more than that, depending on what you're doing, is almost impossible, if not impossible, especially as politics becomes more and more uh, party lined, more and more, diverse from each other.
Yeah, polarized, one might
Polarized,
say.
that's a word, yes. Yes, polarized, that's a word for it, yes. But I think it really shows just the difficulty of picking a jury who is completely impartial, all 12 of them. So I think you said it very well, that especially now, there tends to be picking from both sides of the aisle and hoping that it meets the middle somewhere.
Indeed, and that is an ongoing problem and a question, because there are people that assert that in certain cases the jury was not impartial, or in some way the jury may have been contaminated, or that the jury selection process did not work as it should have. And that is an interesting question and an interesting problem that arises on occasions. And although people could argue theoretically about any particular case, the cases where this becomes the biggest issue are in high profile cases that are covered by the media, because in those cases, many people observing the trial have an emotional investment in, or moral investment in, how the trial comes out. And so once the jury chooses to go against what they would have preferred, they then question the jury in various ways. They question their intelligence, they question their ability to look at the law, they question whether they were truly impartial, they question whether they had been selected previously for some bias that they might have had. And of course, legally speaking, these are questions that are problematic for the government, because as questions they undermine the legitimacy of government policy, and that's always a problem that arises there.
Yes, definitely so. I think, especially, you could see it all the way back from, say, like the O.J. Simpson trial to the trial that just finished recently with Derek Chauvin, where you have seen kind of both people coming out saying, like, no, the jury wasn't impartial. The jury had a bias because they didn't move the district, or didn't move the location. What trial was got tampered with in the O.J. Simpson case, blah 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 blah. You hear all these claims when a verdict comes out that wasn't as favored. Now with the Derek Chauvin case, I think the verdict for many people was the favored outcome, but for the people who, I guess you could say, see the jury system as more of a pure concept, they're a little bit worried that this jury couldn't have been impartial.
Yeah, and of course there's other cases. Casey Anthony, um, George Zimmerman with Trayvon Martin. That's another case where there were a lot of protests and a lot of people were unhappy with the outcome. Now that being said, I'm not making a judgment specifically on any of these cases as to whether the jury did their job uh, internally consistently or externally consistently, or whether they were right or wrong on the decision they made. But what I'm saying is that there are many cases where people do question it, and it is important for the courts to establish a reputation of having reliable juries.
Yes, yes, definitely. Even if you can't find 12 equal people who are impartial in the total sense of the word, which in human nature I think is, like we talked about earlier, almost impossible to find even one person that way. You still want to make sure that you create a 12 people, or create a juror, or yeah, create 12 people who have who will see something as evenly as possible, even if they do have their biases because of, whatever reason they list for it. The idea is that those 12 people in a perfect mixing pot will come up with being able to view something as evenly as possible.
Indeed. So anyway, I'd like to go over one more amendment to the Constitution before we proceed. So that is the Seventh Amendment of the U.S. Constitution, which states in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So this refers to civil claims, civil disputes, where the controversy was above $20. Now, in those days, that's actually quite a bit of money. Nowadays, not as much. So people can interpret how they want to look at that. But anyway, it says that the right of trial by jury shall be preserved, even in those cases, and that similar to other cases, there's also not a double jeopardy, and also that those cases shall be that no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law, of the common law, that is. So, in that says that these disputes should not be tried again unless the law specifically allows it. And so there's different ways to look at this, but essentially this means that trial by jury also applies to other cases than simply the cases where it is a criminal prosecution.
For sure, it's not civil and criminal law are the two, major law things. And I forget where I was discussing with this with somebody. I think it was just a friend, and we were discussing the differences between criminal and civil law. And civil law is much more kind of, doesn't even have it's criminal in nature a little bit. Like if someone runs over your fence, that's more of a civil charge than say a criminal charge for doing so, unless if it ends up hitting, somebody, or anyway. There's differences between both of them, but they're still important to come up with an outcome. So I don't know if I explained that very well, but
Uh, yeah. So anyway, now that we've looked at how the Constitution deals with trial by jury, and I think it's important to note that the trial by jury is established not in the original text of a constitution, but rather in its amendments, because many people thought that the constitution was not specific enough on these things to protect the rights of various people in these United States. So, in that sense, that was a concern that people had, a concern that they could theoretically be tried without a jury, that uh, an indictment could be made without a grand jury, that there could be double jeopardy, among other things, and things like that. Those things were considered important by many of the founding fathers, so they considered that as being something significant enough to place in the U.S. Constitution in order to ensure that the rights of the American people would be protected.
Definitely so, and I think that showed a lot of foresight on their behalf as well. And we had a whole episode on the founding fathers as on our show too, if anyone's interested in them. But it's just amazing that they were able to come up with so many things that we still really use in today's atmosphere, even though it's been many many years.
Indeed. So I think that one thing that some people like to bring up from time to time is the idea of jury nullification, which is a case wherein the jury decides to vote in a way that negates the legal requirement of the law. So that would mean, for example, if a law was made banning a particular action and a person was indicted by a grand jury and was put to trial, and now the petite jury is hearing the case, and the petite jury decides that this person did indeed violate the law in the way that the prosecution states that this person violated the law, and they come to an agreement with that, but they also decide that they don't like the law, so they're simply going to vote not guilty, even though internally they understand that the person is guilty of breaking the law as it is written. And the question then arises whether this is a legitimate use of the jury's power, whether this is something that should be legal, whether this is something that is implicitly allowed in the law, or whether it is something that in theory should be punishable, or that should be punishable but is not punishable because of a way that juries operate.
I think I'm more along the lines of the last one, really. I think that there's not really anything in the law, from my understanding, that says that they're not allowed to do that. And until there's something that is in the law, or at least more clearly defined, then then you can start to say that it shouldn't be allowed, and potential charges could be made for doing so. But from my understanding of the law, I don't really think that that is that case.
Yeah. Well, I think the problem that I have with the idea, to be honest, is that it takes the idea of nullification, not just in jury nullification. There's also in U.S. history something called the nullification crisis, where people like John C. Calhoun wanted to nullify federal laws by simply not enforcing them in the states. And this is actually happening today in some cases, for example, laws on various drugs. But the problem with nullification of the jury or in law enforcement is that it undermines the authority and character of the law itself, which I would imagine, of course, is the purpose, but also does not lead, in my view, to a consistent and stable legal system, because it can lead to a series of superfluous laws that are on the books that have no reason to be removed from the books because nobody's enforcing them anyway. So someday someone can come around and enforce them, and we can end up in situations where people could be penalized for pretty much any reason, where politicians vote in favor of laws under the expectation that those laws are not actually enforced simply for publicity reasons. We could end up in a situation where a genuinely immoral act is justified through jury nullification. And because I don't take a majoritarian idea of morality. I don't think that morality is necessarily up to the people in general to decide and agree on. So, under that theory of morality, if there are a group of people that together decide that they're going to behave in an immoral manner, or to justify something highly immoral, such as, let's say, hypothetically, someone is murdered or raped, and the people on the jury are in favor of that idea for some absurd reason. And people might say, well, that's absurd. Nobody would ever say that. But obviously, this is the position that people have in regards to abortion. That is, that people consider it, people who consider abortion to be murder think that people who are doing this in a legal sense are being immoral when they do that, when they support abortion in legal cases. So that's an example of that. But I'm putting a more extreme example that both sides, even people that are pro abortion, can agree with to illustrate the point that I'm making. And that is that if the jury can simply decide to allow anything they want to happen by denying the state's ability to punish criminals, it leads to outcomes that are based on that. And personally, I'm not very happy with the idea of those outcomes. I think that the government does exist, not necessarily to apply the fullness of morality to everyone, but at least to apply significant enough morality so that people don't go around killing each other in unjustified means. So in that sense, that is something that I see as a problem that can be legitimized through jury nullification.
That does make a lot of sense as well, and a good way to kind of view it. The only counter question I have really is, how would you not necessarily fix the question? It's kind of a fix, but how would you, let's just say, get rid of it, and but still there's gonna have to be something to replace it. So I guess what's gonna replace it if you decide that juries no longer can do that?
Well, that's an interesting question, because what you can do is you can enforce a criminal penalty on jurors that do that. That is something that you could do. Obviously, people can just keep it secret, and if the other jurors in that trial aren't willing to communicate that such a thing was conspired, then there's not really evidence to go on in that sense. Now, one thing, now of course that depends on how you view trials of jury, because as I have said previously multiple times, I'm not actually in favor of the idea of a trial by jury of peers in the same way that a lot of people are. So what I think is important is that trials follow evidence, and that anyone who is a juror should, rather than putting out a decision regarding the guilt of the defendant, they should follow that decision with the particularities of evidence by which they consider that person guilty, or their objection to evidence by which others might have considered that person guilty. So, in that sense, that allows, in the case of an appeal, someone to understand exactly why a person was considered guilty, and therefore, if a particular piece of evidence should be found to be faulty from the original trial in an appeal, the court can't simply say that based on the previous juror's opinion that this person is guilty, we maintain that that person is guilty as previously stated. They have to actually look at the evidence, and if the evidence that has been rejected was evidence based on which the person was declared guilty in the first place, and of course there would necessarily be required multiple pieces of evidence. If therefore the multiplicity of evidence is negated by the discovery that some of the evidence is false, then the person would necessarily be declared not guilty, and it would be understood as deriving from the evidence that was presented in the case. Whereas under the current system, what would have to happen instead is, rather than looking at whether the original evidence is maintained, they instead have to bring up all the same things again, and they come up with a different decision than the original one, rather than a decision that is in criticism of the original one, whether in a negative criticism or in a positive criticism or approval or maintenance of the original argument. So I think that convictions should be based on evidence, and although evidence are presented in cases, many times jurors don't actually think of it in that way. And I would posit as an example of this a statistic here from 1976, but because the law is generally similar as it was then, I would consider this to be still valid for today, where it was discovered in a survey that 50% of Florida jurors studied thought it was up to the defendant to prove his innocence, which is contrary to U.S. legal doctrine, where there is a presumption of innocence for the defendant, and therefore the prosecution must prove the guilt of the defendant. And therefore, because the jury operated in a way, or potentially operated in a way that was counter to legal principles, that can contaminate the outcome of the trial. And therefore, by having more strict requirements for the format in which someone may be convicted or not convicted, that is the format of a verdict, by requiring the inclusion of evidence in the format of a verdict, I would say that would be an improvement. But of course, at that point, if we're asking questions in regards to the format of a verdict and people's understanding of proper legal doctrine, we end up into a case where the idea of a jury by people who are selected out of the general population becomes less viable than an idea of a jury of jurors, that is, legal experts. So jurists Jurors are the jury, jurists are legal experts. And what I'm
Mhm.
saying is that the jurors should also be jurists, because under that principle, we would have the ability to have more stringent standards on how verdicts are established than what we currently have.
Right. I have two things to mention in what you were talking about there. The first is not necessarily an example of it happening in real life, because I would think it would be hard to prove the concept of working in real life, the concept of 12 people of your peers working. And it's with a movie, and we all know that movies are not necessarily 100% true. But I'm assuming anybody who's a big legal fan or was in high school in a certain period of time has probably seen 12 Angry Men. And it was a movie about 12 juries who were sitting on this trial with the person. I don't want to necessarily spoil the movie, but it was kind of showing who, 12 people could be on a jury. And you had like the super emotional guy, you had the guy that was focused on like one thing and that's it. He didn't care about anything else. You had all these different like stereotypes of what a person is who is a peer on the jury. And it could go back to what you're saying as well. If you view it in a more cynical way, you could say, well, having these 12 people be all these different ways and having it work every time is probably going to be a lot less efficient and a lot less practical than having a jury of experts. You could also view it that way. But long story short, they ended up being able to solve the case right because there was one person who kind of stood up for it and said, no, this is the fact, and he was able to convince everybody, and they got the right verdict. But again, if you also want to view it cynically, you could say, well, what if that one person got, evidence tampered to, got persuaded to say these things when he may have not even actually believed it because, say, like the mob showed up or he got money or whatever reason you want to give. And now, the jury and the outcome of it is wrong compared to somebody who maybe just focused on experts and evidence and uh, the facts of the case and not so much like the emotional side that a lot of people who aren't experts are going to be more focused on if you believe in psychology of the mind and all that.
Yeah, and
And no,
yeah,
go on.
and I think that's another point here is that in regards to corruption and evident and not evidence tampering, but jury contamination. If you have someone who is an expert on the law, then both of these can be dealt with more easily, because uh, jury tampering, in that case, the person would still have to follow particular standards of procedure that he would be able to follow due to him having that expertise. And likewise, in the case of corruption of some kind, it would be more easy to hold such a person accountable, because such a person would would have as a requirement for his job to be accountable in the precise way, and to avoid particular types of corruption as is legally required. And therefore, someone who is held to a higher standard uh, is it is possible to have someone who is held to a higher standard, because you're establishing a situation where a person is required to be to a higher standard, which you can't really do for a jury of peers, where obviously they are held to a high standard, but you can't go the extra mile, because these are people from different walks of life that are not specialized in that way.
Yes, definitely. And to talk about the statistic you made, about that they wanted the burden of proof to be on the defense and not the prosecution, meaning that they want the defense to show that the person's not guilty when it should be the other way around. Uh, the events that came out from Derek Chauvin and the juror 52 who has kind of spoken up recently and been on the news, he at one point said that he was basically looking for the defense to make their case. And some people took that in what he said, and he said a little different than that. But they took what he said, meaning that he was looking for the defense to prove that Derek Chauvin wasn't guilty and not the prosecution. So if you believe that that may have been what he thought of or what the jury kind of was feeling because he was talking about the jury and not just himself in that question, then you could say that they fell into that statistic as well.
Yes. So you were going to talk a little bit about that case, a bit about that juror. Did you have anything more to say about that?
Yeah, just a little bit more. The main thing I kind of wanted to bring up in this, and we talked a little bit about it already, but the idea of basically what some people believe he did, and we don't know it for sure yet, but he had to answer this questionnaire, I guess you could call it, and so did anybody else who got called on jury duty that day. And you had to answer these questions based off of your beliefs. You know, everybody has to do that for anything, but since this was so high profile, there was a lot of questions. And long story short, he ended up being on the jury and ended up deciding on all three. We all know what happened from it. But like a week ago after this, he got found after his media appearance being on a podcast talking about, the Black Lives Matter movement. Then he got found in a picture with him having a Floyd T-shirt on and an event where his parents were speaking. And he said he wasn't there for that event. He was there for Martin Luther King Jr. Day
But that
or
was before
something.
the
But
trial.
this was before the trial,
Yeah,
yes. We need to make that clear as well, yes.
yeah. Because
And so
after the
these
trial, it
all,
doesn't matter. But before the trial, that certainly uh,
yes,
is relevant to the jury.
yes, of course, yeah. So all these things keep coming out, and some other things I haven't mentioned, and it goes back to the questions. And there was a couple of questions on there that some lawyers on YouTube that I follow and listen to, and some other media sources have said that if he answered these questions wrong, or he lied on these questions, it could be grounds for a mistrial or a retrial or whatever terminology you want to use. Uh, but long story short, the main reason I wanted to bring that up is the idea of a juror going in and persuading these 12 people and changing the case, or simply being on a jury and lying to get there, is a possibility as well. We don't know if he did that yet for sure, but there's reason to believe that it was more possible than, say, a week ago.
Indeed, it is possible. Now, of course, I think it will have to ultimately depend on the proper legal authorities to decide that, because I don't have all the evidence. I don't know exactly what happened. I have heard of this story a little bit before, although, nevertheless, once again, it's not up to me how these things end up. It's up to prosecutors, it's up to judges, it's up to juries, it's up to uh, bureaucrats in various functions. So, in that sense, just like in the trial, it was up to the jury to decide on the particular decision, and it was up to the grand jury to decide whether it was possible that a trial might be held. So it goes back to the jury, and of course, people have looked at profiles, because the jurors in a lot of these trials are anonymous to the general public. although later on they might reveal themselves, but general qualities of these jurors are revealed. For example, in that trial, we heard interviews of potential jurors. So, in that sense, there is an anonymity, but also there is a a publicization of some of these matters, and of course, anybody who's actually in the courtroom would also have a greater understanding of the jurors as well.
Hmm.
So, yeah, there is anonymity, but there's also a lot of things that are revealed.
And just one more question when it comes to just this trial itself, since this is more of a recent trial that made big news. uh, One thing, and then I'll get to the question. There was I believe it was by New York Times, but they released basically the professions of the people who were on the jury, but didn't say their name, of course. But some people were thinking that that would be a pressure to the jury, and then it goes to my question: do you think, in more high-profile cases like the Derek Chauvin event, that they should move the location of the trial?
Well, the Constitution, as far as I understand, would not allow someone to be tried under a different jurisdiction than the one in which the crime was committed. Now, that being said, it doesn't mean that they could theoretically meet in a different location. Uh, Sorry, that they couldn't theoretically meet in a different location. So I'm not entirely sure exactly what the law says on whether or not they're allowed to meet in a different location than is usual. I think they might be able to in some cases. I think that in regards to this, the Constitution certainly requires that the jury be composed of people from whatever district the defendant is in. So in that sense, that is one way in which the location is not changed, although those people would also have to, together with the defendant, go to wherever the trial is being held. So I don't know the exact law on whether it's allowed or not. Now, in the case of if there's a problem with riots and everything and big protests, I think that is an issue that is occurring. Now, of course, in some cases, for example, in Britain, as far as I'm aware, sometimes they will have anonymity for when a trial is happening and who exactly is being on trial, because they don't want people to mob the courthouse, which I think is something that should be avoided. Uh, to to have people mob the courthouse. I think that as long as the rights of the defendant are being protected, uh, the media shouldn't really, and people besides the defendant shouldn't really have a particular access to the court. Uh, that is to say that other than whoever the defendant and the prosecution wants to be at the courtroom, I don't think that there is a necessity to reveal when a trial is happening or in which particular courtroom it's happening in. I don't think there should be, because, as I said, media publicization is a problem. People mobbing the courtroom is a problem. Um, Potential riots are a problem in some high profile cases. So I think that some trials are much too publicized, that in some trials there's much too many people protesting at the courthouse. That although I think that certain records should be public, I don't think that the general public, although the trial is public, so the general public does have a right to have knowledge and potentially information on the trial, according to the Constitution anyway. I think that in some ways that can hold things back. I think it should be more an invitation affair rather than a particular thing. Now, that being said, nowadays we have more advanced technology, so people can see a trial happening from far away, and theoretically, the trial could be public in that way that it's put out on public airwaves without revealing the exact location of the courtroom. But as today's technology, and we have to understand it wasn't always like that, and we don't always know whether it will be like that. So I can't really say that that excuses that constitutionally from a previous system where people would be able to go to the courthouse. So in that sense, it's a complex question. I think it's something in which I understand the idea that is being held here, because the publicity of the trial, not people making publicity, but the trial being public, helps protect the rights of the defendant, and also allows people to see the legal process in action. So in that way, it is advantageous in that sense, but it's also disadvantageous in high-profile cases. So I think maybe there should be some reform there, but of course I don't know about particular court rulings or local laws, and how different jurisdictions choose to deal with those issues.
Hmm. I mean, I would think in a perfect world, even in the super high profile cases like the Derek Chauvin and George Floyd and all of that, and even way all the way back to like O.J. Simpson or Casey Anthony, like you mentioned earlier, any of the high profile ones, the jury on that case wouldn't feel pressured by media or anybody else at all and be able to make the ruling and be focused just on that event. But I also think that's a little bit silly to think that the pressure that the media has isn't at some point the jury is going to feel it as well.
Yeah, it's an ongoing question and an ongoing problem. That's why I think we should have people that are more expert in operating in that situation, so that they are less likely to be pressured, and also that in the case of pressuring, we should have legal means to deal with pressuring and to prevent that type of event from corrupting the legal process. Because the integrity of our trials, whether you are in favor of trial by jury, in favor of public trials, or against that, what is important is the integrity of the judicial system. And so, whatever happens, that is, I think, a focus that people should always strive to have integrity.
Yes, yes, definitely so. If the jury system is broken, if the legal system is broken in that way, or the judicial system really in this case is broken, then that's not going to go very well for the future of the United States.
Yeah, because even if there's people that don't like what we currently have, I'm certain that they would prefer what we currently have to work as it should, rather than to fall apart.
Yeah, for sure. I would think so.
Yeah. Now, of course, there's always somebody who is I want to see the world burn. I want everything to be crushed down so that we can rebuild from the ashes. There's people like that. I I disavow. I don't think that that's productive. I don't think that that's very virtuous. So in that sense, that is my position on that.
Yeah. The total anarchy is not necessarily the perfect solution for this or any solution really.
That and a functional a functional imperfect system, though being less good than a more perfect system that is also functional, is still better than a dysfunctional imperfect system.
Yes. Yes. I think a lot of people would like the system to be better, but it's still better than many other examples in the world and things like that. So we're not the worst, but I think many people would like it a little bit better.
Yeah. So on that note, I think we should wrap up. I put forward that I think I explained things as the Constitution explained things. I put forward ideas on how it works, how I would like to maybe change things, my thoughts on jury nullification, and the importance of integrity in the judicial system.
Yes, and I'll just conclude saying that a jury of the peers is a very old concept, a concept that we're still using today. So I think we still need to figure out the weaknesses and strengths of it, and maybe make for future, jury selections in high profile cases or just any court case to be as best as possible. Because we don't want the jury to make wrong rulings. I think we would all prefer right rulings more often than wrong rulings.
Indeed. So anyway, you can find me on my YouTube channel where this is currently airing. Um, if I might look over the stream later. If it's damaged, I might replace it with a recorded version that I'm currently recording. But anyway, you can also look at my book Actionable Justice, which isn't about the jury process, but more on the concept of justice itself. You can find that on Amazon Kindle, or you can buy a physical copy at Taurus Necris. Over to you.
So now I'm the Breakdown with Berckenhoff is my YouTube channel. You can find all my independent YouTube videos there, or my live streams there, or you can find my live streams at the Breakdown with WB for Twitch and everywhere else where all my live streams get broadcasted as well.
Okay, so our beautiful audience, I thank you all for watching. I hope that you're going to have a good time. If you ever find yourself in a judicial situation, I hope that you have an appreciation for how the system works and for the integrity that is required of people in the system. So thank you all for watching, and we will be seeing you all next time. Anavultus over and out.